granddaddy bought 100 acres of land in 1917, and it's just been passed down through the family. My cousins and I want to split it up or sell it. Now what? The classic lawyer answer is always, it depends. The heirs property type of litigation is pretty much exactly what it sounds like. In our scenario about granddaddy and his 100 acres, we would file a case asking the court to determine who are the heirs of granddaddy and to determine the percentage of the property or profit to which each heir may be entitled, and to ask the court to order that the property be partitioned. In the case of the 100 acres, one option would be to seek a partition in kind, which means the property is literally subdivided amongst the heirs. In most instances, it's impossible to divide real property fairly and equitably. How do you go about dividing a single-family home? Usually, the court will order the property to be sold, which means each heir gets their appropriate share of the proceeds. In an heir's property case, the heirs get first dibs to buy out the other heirs at fair market value or at a court-appointed price. Otherwise, the property will be sold on the open market, which is what we try to obtain that order, which allows that. If the judge will not allow us to sell it on the open market, or if it won't sell on the open market, then it can go up for judicial auction. Once the property is sold, the closing cost, the cost of the partition action, and any necessary judgments or liens will be paid off first. Then, whatever proceeds are left will be divided among the heirs. Sometimes, however, in a case like granddaddy's land, one person has been taking care of the land for 10 or more years, and they want the court to decide that the land is theirs and not the heirs. This would be a case for adverse possession. And that dispute between the neighbors about the fence line? This is a case for adverse possession too. Adverse possession means one person has exercised control over the land belonging to another for a period of 10 years or more, in a manner that is open, notorious, and hostile to the actual ownership rights. These cases are very fact-specific, and you need to work with an attorney who has experience litigating those issues. If you have any questions about heirs property or other real estate needs, please do not hesitate to reach out. At Grimm Rupert, we look forward to meeting you.